Okay, good afternoon everyone from the UK. It's 2 p.m. in the UK in Newcastle. So welcome to everyone to our final webinar in this series. My name is Jill Rowell and I'm Academic Advisor with Turnitin and Plagiarismadvice.org. And as I said, this is the final in our series of webinars. Congratulations if people have managed to stay with us for the whole 6. I hope you found them very useful. This final webinar is going to look at case processing and give us some issues for consideration when we're actually addressing cases of plagiarism, so that we can ensure that students are treated fairly and that our treatment of them is transparent. We've talked a lot about that in the series of webinars when we've been talking about policies and procedures. Adrian Slater is our speaker this week, and I'll introduce him in a second. He's going to talk around some of the issues on our tip sheet on this topic, which I'll share with you in a second. Hopefully there'll be a chance for you to interact with Adrian. He's got some questions for you, and if you have any questions, if you'd like to type them into the chat window, we'll pause midway through the session so that you can put your questions to Adrian. This session is being recorded, so if you want to pass it on to colleagues after the session, or if you want to listen again, that will be possible. All the other webinars have also been recorded, and I can provide you with a link to those at the end of the session. Just before we get started and I introduce Adrian, I just thought it might be useful to find out where people are joining us from today. So I've put up a poll for you there, just so we can get a feeling for where colleagues are from. So excuse me while I have a look at who we've got today. We've got colleagues from Africa, Asia, Central and South America, quite a few people from Europe, as you might expect, Middle East, and hello to our colleagues in the US and Canada. Obviously it's quite early there. That's great to have such a global representation today. Thank you for that. Okay, so we'll get started. Our speaker this week in our final webinar is Adrian Slater. Adrian is a solicitor and head of legal services at the University of Leeds in the UK. He left private practice as a lawyer over 12 years ago to join the university. He says that he was fed up of working outrageous hours. I'm sure a lot of lecturers will find that very similar too. He describes himself as a pragmatist, and he's keen to avoid the casino of court. I don't know if that's happened working in the educational sector. He's been called upon to give advice on plagiarism cases and policy development in lots of different areas, not just within his university, but also in institutions external to the university. He's spoken at many different conferences in the UK and in Europe on the subject. It's a mistake to think that he spends all of his time looking at plagiarism cases. He tells me it's just a very small proportion of his work. And we have said before, that plagiarism cases are, deliberate plagiarism is often a very small proportion of academics' work. He also advises on joint ventures, intellectual property matters, and other student-related matters at the University of Leeds. He's a regular and popular contributor to the International Plagiarism Conference, which was when I first met Adrian some years ago. He's been our warm-up act for the past few years, and he hopefully will join us at the conference next year. He's never been afraid of to ask the probing questions and to generally get people talking about plagiarism and their policies and what they should be thinking about when they're addressing plagiarism and their policies. At the recent conference, he talked about the wild, wild west of plagiarism with a sort of a cowboy and western theme. So he might tell us a little bit more about that in his session today. But I'd like to welcome him to host this final webinar on case processing with some issues for consideration. So I'm going to unmute him now and let him talk to you. Go ahead, Adrian.
Hello, welcome. This is my first time out doing this kind of seminar, and what I have realised is I look like a sports commentator. So the big match, here we are. Um, what I'd like to encourage people to do is please ask questions as we go along. You can use pseudonyms. I've personally bagged Prince Charles, whatever you like. If you say you've got a friend, we know the problem is not yours and you can share it, knowing that no one else will attribute it to you. What I thought we'd do is look at the big picture first of all. And I like this quote that's up in front of you. Education is not the filling of buckets, but the lighting of a fire. Now, the reason why I like that is for two reasons. First off, it kind of gets the sentiment that progressive education is about protecting originality and creativity. That's fantastic. Second thing is that the quote itself is subject to misattribution. People think it's William Butler Yeats, but if you look on the web, you can see there's a massive scrap as to who actually came up with that quote. So, even a simple quote that's supposed to be historically accurate, you can see is subject to big controversy. So what I'd like to start off with is the other big question, I suppose, about plagiarism is really, is a judgment about plagiarism purely one of academic freedom, academic judgment? Because if it is, you can make it up as you go along. So first question, you've got along, I think, your right-hand side of your PCs, you might see. It says, do you believe plagiarism is part of academic judgment and never open for review? Could we have a poll on that, please? Yeses or noes? Ooh, 100%. Okay, well, that's quite interesting because that's a very good starting point, and clearly it gives you Feinites. People cannot chat you. But hopefully in the material, you've also got reference, perhaps Jill on the next slide, to a case here in the UK where the issue of academic freedom and plagiarism was considered. And it's very interesting what the judge said. What he didn't say is that we will never look at plagiarism cases. It is not always a matter of academic judgment. So I guess that's easy for some of us. We can say, well, following a fair process, that could be open for review. So could perhaps the amount of the penalty imposed. But the actual judgment itself, whether or not that's plagiarism, I guess we all thought for a long time that couldn't be touched. But interestingly, what the judge says here is maybe it can be. And he quotes the example where you've got literally chunks of script that haven't been put in quotes that are the same as other script. He's suggesting that's not a matter of academic judgment. That's just a technical thing. Is that the same or is it not? And in those cases, that's not a matter of academic judgment. Now that's interesting and slightly frightening, because it means that if we think our decisions can't be reviewed there, they can be. So that case is rather interesting. Commentators are having a good chat about that. It only came out in May, and we'll see what the implications are of that. Okay, so I think we may see the slow erosion of plagiarism being clearly within academic freedom. Who knows? So quite an interesting one. You should also have the case processing diagram. That's the one. Okay. What I want to do is sort of go anti-clockwise and tick off the headings I've mentioned there. And maybe as we go along, people can share some experiences. So the first one I've mentioned, plagiarism is about individual responsibility. Okay. And I mentioned within there the need for training. Now, we haven't got it up as a poll, but I'd like to know how many organisations do training and actually make training compulsory for students. This legally, it's quite interesting. If you look at the areas like discrimination law and health and safety, the courts have been pretty clear. You can't hold people responsible for not discriminating or breaching health and safety unless you train them. You can have all the codes and all the policies you like, but if you're not training them, we're not going to hold them responsible. So I think the clear message is coming. If you don't train your students when they're at your university, then maybe you have difficulty in holding them responsible when they do commit plagiarism. So maybe those statements we make saying you will not plagiarize just will not work of themselves. And I think that's going to be an interesting development. What I want to do also as a discussion point is discuss a case that a friend of mine had to deal with and see what your reaction is. A few years ago, at a hypothetical university in the north of England, what happened was we had an international student who submitted his PhD, got his PhD, put it into the library, and what happened was a clerk took it off the shelf, started reading it, and went, flipping heck, this is déjà vu. This clerk had done the particular topic at undergraduate level, and what she said was, this is standard undergraduate textbook stuff. And we looked at it, and we stopped counting when over 48% of the PhD was standard undergraduate text. Got the student over, couldn't really defend himself very well, popped back to the Middle East, made a finding against him. First problem was a practical one. He'd gone back with his PhD certificate. We kept on writing to him. He obviously didn't get the post because he never returned his certificate. Who would you hold responsible there? What about the supervisory team, the internal examiners, and the external examiners? Forget the legal bits, but 48% of copying from standard textbook. Who do you think morally culpable? Interesting to see what people's comments are coming in. We certainly hung the student out to dry. What would you do about the examining team and the supervisor? I'll tell you what we did. We discouraged the examining team from examining for a while, and we sent the supervisor off on a plagiarism course. And he didn't supervise for a few years because we did feel there was a bit of culpability there. 48% literally copying, and they didn't notice it. The good thing, though, was the defense of the examining team. And they said, sorry, old boy, we don't look at undergraduate textbooks. We're researchers. We've got no interest. How would we know? Okay, and I thought that was quite interesting. Very extreme case, perhaps. Perhaps worth having a look at question 2. Does your institution use published tariffs for penalties? Let's have a sense of that from people. If you could vote away. Ooh, initially. Okay, so it's changing slightly. We've just about got the majority saying no. Now, I wonder if part of the concern is that they perhaps lock you into a result. So one thing you can do is have indicative tariffs. We certainly think they're a good idea. because the truth, we do treat students differently. So if you have a first year student whose first offence, fairly minor, we're probably going to treat them differently from a student doing the same offence in the third year when they've been through all their training. So we do indicate that. Someone said, what does a tariff mean? I've seen that on the emails. A tariff means a list of possible penalties. So, for example, you might indicate on a minor discretion, perhaps an isolated case of someone not using quotes just the once, you would give them a caution. Whereas at the other extreme, if substantial text is verbatim copied, expulsion. So you mark the difference between the two. What's interesting now, my screen had gone blank, that's okay. So I think it's very interesting about tariffs. It seems to us that the Ombudsman here is quite keen on them. And so I think they're a good idea. Work for transparency. And if you are going to take action against someone, it gives you something to refer to, and it helps you with consistency. The other issue I'd like to identify as something that's come back to bite people is confidential chats. Now, I suspect, common to most people, in our processes, we have an informal level and a formal level. So the informal level is dealt with at schools, where we encourage more minor intrusions to be dealt with at school level. And classically, they'll start off with an informal chat by a tutor saying, this has come to our attention, perhaps the Turnitin return or something like that. And then it's interesting as to what's discussed. And straight away, if we don't watch it, people go to off-the-record chats. Now, I bet who here has had those kind of off-the-record chats, try and resolve things? I just like to see the emails coming in. As a lawyer, I have these all the time. They're called without prejudice discussions. Okay, because you want to do a result. You want to get rid of it. Problem is, it doesn't get rid of it. So you've heard these things off the record. What do you do with them? So if you like, the student has made these prejudicial comments, perhaps admitted some culpability, but you've agreed it's off the record. What can you do with those comments? And I think that's highly problematic. So what I would advise people, and this is a difficult thing, when you start a conversation with students, you're going to have to clarify the status of the meeting. So let's have a chat, but I have to tell you now, this is all on the record, which might mean doing deals becomes more difficult, but at least it gives you the clear line. So you know if they tell you something that you need to use later, you can do it. And we certainly had situations where some of our staff have been listening to students very carefully, perhaps a personal sub-story. Students been saying this is confidential and it wants to be used later on. The student says, hang on a minute, you can't. I told you off the record, and it stuffs us. So I've got a question here also. I think it's question number 7. Does your institution provide training to frontline staff on how to handle informal chats and confidentiality? Let's just see what the poll says. It's 100% no. Oh, no. Some latecomers. Okay. I noticed that someone said we incorporate this as part of the induction process. That's very good. Okay. It's interesting with my institution. The only time I've been asked to give training on confidentiality is to our in-house mediators. So we do know a lot of people are operating out there without understanding what confidentiality means. So it's a bit of a high-risk area. I suspect most of our cases go away through informal chats and informal action. And I don't want to stop that, but I just want to caution people about consequences. The next thing I've got up is complex issues. Now, we find there's nothing like a plagiarism case for the students to start telling you about all the problems in their life and all the problems they've got with the supervisors and how they're rubbish, in fact. And in fact, they plagiarized, but it's not their fault. And they put in a host of factors. And a classic one would be they're being harassed by their tutor, or the quality of supervision or teaching is poor, and they're being forced back onto doing this. So you get a host of issues that become quite difficult in this mix. So let's focus on one of them. Student turns around, says, part of the reason why I plagiarized is because your tuition is rubbish and your training's rubbish, so you can't blame me. Would you deal with that at the same time as the plagiarism case, or would you deal with that as a separate complaint about the quality of supervision? What do people think? Any thoughts on the email coming back on the chat? It's interesting because in this particular case, in the Mustafa case, it was introduced. Would you try and keep the lines clear? Okay, nothing coming through. Ethics saying you deal with separately. Yeah, I would agree. It's a relevant issue to plagiarism. Irrelevant? Oh, you're all on message. That's fantastic. There's a tendency to mix it all in the pot, and I would say try not to do that. I've seen that a number of occasions. I have to say, particularly with discrimination, people introduce that discrimination angle, which I'll deal with at the same time, and it gets very messy. It also gets messy because if you're trying to maintain the integrity and the separateness as judgments on plagiarism about academic judgments, you want to keep that clean. Of course, you've got to decide which goes first. And I guess in most cases, you would say, we'll look at the other complaint first. If that's got legs, we'll maybe pause there. If it hasn't got legs, we'll move on to the plagiarism. Okay, and I think that's very important to get that right. Someone's mentioned, I think it's Jill, about mitigating circumstances. Yeah, can be. That's why you hear the one first. So you might find, let's say, that tuition was poor. Okay, you then go on to hear about the plagiarism. You still find plagiarism was there, but you say extenuating circumstances because you weren't given proper training. We're going to let you off kicking off. Okay, we're just going to give you a caution or something. But I think it's very important you get your sequencing right. And the court's been pretty clear about that. Don't muddy your processes. Definitely not. Now, I've got some questions as well around this. Question 3, a push for the lawyers. This is about process again and hearings. Does your institution allow lawyers into hearings with students, whether it's students representative or representing the university? And that's interesting. I would have expected almost 100% no, but we've got 20% of people saying yes, they do. Now, I wonder if that's a general rule or only in exceptional cases. What's interesting in this country, the message coming through from the OIA is that they don't expect generally lawyers to be allowed in, but generally. So it's very important, I would say, when you're drafting your policies and guidelines, you don't rule it out. Okay, it's very important to allow the possibility in. But beware, and this is a common problem. People say, we'll allow lawyers in, but only as supporters. Have you ever tried to shut a lawyer up and say, be quiet, you can't say anything? That's extremely hard. Once they're in, they're in. So I think if you're going to try and enforce that rule, you're in real difficulty and you need a very strong chair. Here at Leeds, we don't rule it out totally, but generally we don't allow it. Okay. And I can't think of an occasion to date where we have allowed one in. Now we want to take a break in a minute, so I can also take in other people's questions, but let's just a couple more polls before we take that break. Number 4 is kind of reverse of that. To be emphatic, do any institutions never allow lawyers into hearings? So absolutely verboten. Right, so 2, no more than. Okay, about 50% say absolutely no. Okay, could well get away with that. I would personally advise my institution to be just a little bit more flexible, because there could be occasions we think that's appropriate. And then let's finish on number 9. Does your institution allow hearings to be recorded? That's 100% no. Oh, no, it's not. Sorry, premature. So we've got 2/3, roughly, maybe a bit higher, saying no. And that's fascinating. One of the big problems we're experiencing is that even if you don't allow them, the students will bring along their mobile phones, and they will either overtly or covertly record. And they'll record not just the hearings, but meetings with tutors, building up to the formal hearing. I had a recent case of that. Now, what's interesting, certainly under English law, if you look at the employment field, tribunals have said there, even if you don't allow recordings, if the recording is relevant and it comes to court, courts will say, we want to hear those recordings, even if people didn't consent. So that's a bit of a problem. How are you going to enforce that? How are you going to stop students covertly recording anything? You say no mobile phones allowed in, like in exams. And then if the reality is that's difficult to enforce, then do you allow staff to record? Or do you just say, we'll just have one audio recording that everyone can rely upon? I don't think at the moment the issue is being really addressed. I suspect the best thing you can do is to say in your policies, we don't allow it, we don't allow mobile phones in, no one can do it, a minute will be taken of the meeting, everyone can see the minute, making sure you destroy your notes behind the minutes taking after the meeting, and take it like that. Someone's raising a question about covert recording by attendance. Monica, I don't know who attendance would mean here. Do you mean the students themselves? Or do you mean their followers and supporters? The problem you've got, unless you're going to do a body search, you'll never know. And you'll never know whether they're going to use the recording, sending it back to you, or just a challenge behind the scenes what was said. And it's a real difficult area. And I suspect technology will ultimately drive us towards accepting audio recordings. And I think that's probably just the way it's going to go. So, the chance for me to have a break from talking. Any other comments people want to make on the chat area?
Thanks, Adrian. Does anyone have any other questions? I thought, Adrian, would you maybe clarify the role of the OIA in the UK if people aren't familiar with that kind of role? Because it may, I'm not sure whether other countries would have such a ombudsman as we do in the UK.
Yeah. The OIA scheme is despicable. It's terrible. It's quick, fair and efficient, and gives the student on an ombudsman scheme a remedy fairly soon on in a process. So as a lawyer, obviously I see that as problematic. because students can quite easily go to the ombudsman scheme once the internal procedures have been exhausted. And the whole, I believe, of HE establishments in the UK have signed up to this ombudsman scheme. What's interesting, if you look at the Mustafa case, you can see that he was challenging the decision of the OIA that the matter was academic freedom relating to plagiarism. And so far, the OIA have taken a pretty bullish line supporting that plagiarism is a matter of academic freedom. It seems to be a scheme that's working quite well here, and it's stopping students having the cost of going to court.
Thanks for that, Adrian. Do other countries that you're aware of have similar schemes? I think in European countries there are sort of ombudsman schemes, but I don't know about outside of that. I mean, that might be something that people joining the meeting might be able to comment on, of whether they have that sort of, if for a student, if their complaint is not, is not remedied, they don't feel satisfied by what they've got from their institution, is there somewhere that they can go to take that further?
Yeah, what I'm aware of is many universities, and I think some of them in this country, have a sort of interim position whereby they have an ombudsman who is not part of the institution. So it's an independent person who comes in and gives a decision, and both the student and the university agree to be bound by that. So it's not quite the same as having a statutory ombudsman scheme, but again, it's even quicker, and it's external to the university. And I think those are getting more common. In fact, we've been approached here if we want to do that.
Thanks, Adrian. There's another question from Alan in Ohio about the status of plagiarism and how in the US, obviously, it's an academic and ethical concern, not a legal one, and that's probably the same in the UK, isn't it? But can you talk about that and how the courts would get involved in a decision?
If in this country, I suppose the debate is whether or not it's academic judgment or whether it's an issue of straight misconduct. Courts have held the line. Generally speaking, it's a matter of academic judgment. Now, how would that play out? If a student here were found to be guilty of plagiarism internally, he would have to exhaust the process. He would then have a right to go to the OIA, the Ombudsman. I think he's got something like 6 months to bring his claim. Decision by the OIA. Let's assume it doesn't go the student's way. The student can then only challenge the decision of the OIA through a process of judicial review. And essentially what they have to say is that the OIA, through a process, came with a decision that was wholly unreasonable. Very difficult to challenge. And the courts have said they're reluctant to second guess what the OIA does. So most decisions that go to the OIA end up staying there. And it keeps the matter out of the courts, which I'm afraid saves on lawyers' fees, which is a mixed bag.
I'd be interested to know what other countries, what is it the same in other countries? Is it academic judgment primarily, or is it something which is actually a legal matter? I don't know if people can put their views on the chat window. That might be quite interesting to find out. In the meantime, does anyone have any other questions for Adrian at this point? Shall we continue, Adrian? And then if we have any further questions, we can take those as they come up.
Okay. Well, tell you what, and one area it does get, again, quite murky is where we have students on vocational courses. So I'm a medic, say, and I need to register with the General Medical Council. And if we do them for plagiarism, and we wish to chuck them off a course, that's not just an issue here for this university, but it can get reported to GMC and become a professional misconduct issue. So there can be crossover between the two. And so it means that not only are they possibly kicked out of this university, but they can no longer practice medicine anywhere else. So there's a bit of crossover. Okay, so should we crack on with the burden of proof? Now, forgive me, this might sound like, first of all, a bit of a lawyer's technical dream, but in fact it's really important, and often can be key to whether a student's found guilty or not of plagiarism. So there's distinction, first of all, between two concepts, certainly in the UK. One is the burden of proof, and what that means is normally the university has to prove the student's plagiarized. It's not the other way around, that the student has to prove that they didn't. Okay, so we have to take the case and prove it. Then you've got the evidential burden, which is a slightly different issue. What it says is when you prove things, it's to what level of proof you need to use. So everyone's familiar with the concept of beyond reasonable doubt. So that's the criminal level. And then you've got the civil test of balance of probabilities. Why does that matter? So if you've got a plagiarism panel in front of you and they go, we can't be 100% sure. Okay, we think it probably happened. Most reasonable explanation is the person plagiarized. What is it that you're looking at? Is that beyond reasonable doubt? Is that balance probabilities? Is that a reasonable conclusion based upon the facts? I think it's quite important to know what is the test. Because if you say it's got to be beyond reasonable doubt, the criminal test, that's a very high bar. And what you might want to borrow from is copyright law. Because what happens in copyright law, certainly in the UK, is this. If you've got someone that you think has breached your copyright, so ripped off your academic text, you've still got to prove that what they've done is substantially similar. So you look at their text, you look at your text, and you say, these two are the same or similar. If you can prove that, the burden of proof then shifts. And the person you're accusing has to prove they didn't copy. They need to prove intention, have to prove the copy. Now, I wonder if people ever thought about putting that in their policies. So when you've got two bits of text that are clearly the same or very similar, switch the burden and say, right, student, prima facie case now, you show us that you didn't actually copy. I think that's quite an interesting idea. What we don't know is whether the courts will, in future years, start looking at this issue of evidential burden. Because I think it's key. It's key to whether or not you're going to get a prosecution. At the moment, so in this country, it doesn't look like the OIA are that concerned. You can, so long as you use something that's half decent, so a reasonable conclusion, band of reasonableness in your decision, you'll probably be okay. But I think it's quite interesting. Okay, let's think about some of the poll questions again. If we look at question 5, do your institution's plagiarism policies talk about the burden of proof and the evidential burden? Are they that loyally driven? Now that's interesting. 100%, unless I've lost everybody, are saying no. Okay, now maybe some of them will say, yeah, okay, burden of proof is on the university. I'm guessing that's a different question, and most people will probably say yes, or we live to that as a practice. But you don't address the evidential burden. And I think that's quite interesting, because no doubt many of us are, from time to time, asked to advise people, well, hang on, is this plagiarism? I think unless you address that question, you can't really give a good balanced answer. Okay, what about, someone's asking, increasingly students collude. What about the burden of proof in those instances? So on balance of probabilities, have these students colluded? Same issue relating to evidential burden. beyond all reasonable doubt, balanced probabilities, do we reasonably believe? Exactly the same thing. You use this burden across the piece, and that's where I look at it. Though I have to say, collusion cases, very difficult to prove, because everyone knows it's shut up shop time, and they are the most problematic. I have to say, group work collusion is definitely a growing area, and something that is taxing us. Someone else asked, do you call individual students in for a viva if you suspect plagiarism, or do you call in the whole group? Well, let's assume that someone has committed plagiarism or suspected of it, and it's part of a group activity. Generally speaking, we would take evidence from the whole group and see what they say. We recently had a case of that, where it seemed to us that we had, of a group of 5 people, 2 people doing all the work and 3 people taking stuff off the web. And unfortunately, on the work that was submitted, we picked up the stuff that was plagiarized from the web. And then, of course, we had to work out within the group who had done what. And the 2 people who did the original thinking were extremely upset, because they could realize, unless they could prove which bits they'd done themselves, they were going to take responsibility of the group for the plagiarism. And so that got quite nasty. And the group, of course, fell out. So that can be very, very difficult. And students don't always remember exactly which bits they did. So that's difficult. Perhaps time for another quick question as well. Question number 6. Do you ever reverse the burden of proof when there's a prima facie case? Now, prima facie, lawyers love this kind of Latin stuff, where there is on the face of it a case to answer. So do ever people do that? That's interesting. So is it around about 50-50 at the moment? Okay. Well, I think as long as you're explicit about in your policy, that's fine. Lots of precedents for doing that. For example, if you're looking at a discrimination case in this country, that's exactly the kind of thing that happens. As I mentioned, in copyright law, exactly the kind of thing that happens. And I think it's not a bad idea, because it can stop wasting people's time. Because the burden's back on the student with something pretty obvious, quite frankly. So I think it's worth something to think about. The next one I'm looking at here is giving reasons. Now, I have a story involving another university that I'm familiar with. What happened was that we had 3 PhD funded posts coming up, and we had a lot of people applying. And one of those people applying happened to be someone with a disability. They applied, unfortunately, didn't get the post. What happened, unfortunately, was that the chairman was away on holiday, so Muggins here had the responsibility of giving feedback to the student. I looked at the minutes of the meeting, pretty scant, did the best I could, and gave the student honest feedback on the face of the minutes. That went off. Didn't hear anything from the student for a few weeks. Chair comes back from his holiday and said, Adrian, I understand you wanted me. Here's my email. And this is the real reason why I didn't take the student. And they were entirely different. Now, we're very lucky that we weren't challenged on that. As it happens, I don't think it was anything to do with the student's disability, but clearly there was enormous room there to create trouble. And partly because of that, sometimes people think, let's just not give reasons. Well, I'm pretty sure now, under certainly the UK law and with the attitude of the OIA, you can't get away with it. And you need to give your reasons really early up front. You don't need to give all the detail. You don't need to repeat all the evidence of the witnesses, but you need to give enough that we give them the basis for an informed challenge. And that's what the courts are saying. Now, I'm assuming pretty much everyone does that because that's best practice anyway. But very, very important, you've got to give reasons. And do make sure the reasons you give fall comfortably within your definition of plagiarism. So, for example, some people require intention to be proven in order for someone to be guilty of plagiarism. So you're going to have to deal with that in your reasoning. Make sure you go back to your criteria and you fit your reasoning within the criteria. Very, very important. Next one is data privacy. Now, the good thing is that if you're in the European Union, we sort of generally have similar laws on data protection. So people within the EU will broadly understand about data protection rights. There's some more changes coming online on that area, but we'll all understand similar language. Essentially, what I'm looking at is when you've looked at a case of plagiarism, what do you do with the information at the end? So playing it both ways. If the student is found not guilty, what do you do with the material? On the chat page, what would people do with that material? Not guilty. Just get rid of it. So a quick reaction from people. You can see a few people typing. Return to department. Yes. And you make sure the department destroy. Keep till graduation. That's interesting. Even though they're proven not to be guilty. Okay. I think in terms of data protection law, if they found to be not guilty, you've got to destroy it. Because otherwise, why are you keeping it? They're not guilty, it's irrelevant now. It can only be down there for prejudice, quite frankly. You know, background goss. Okay. The other thing is what happens if the student is found guilty. How long do you keep it for? And I think I've got a question on this. So if we go to one of my questions on that one. Let's have a quick look at it. Yeah, question 8. Does your institution keep material relating to a case of plagiarism for longer than 5 years once it's been concluded within the institution? Interesting. So just about the majority are saying longer than 5 years. Now, I chose 5 years deliberately. In this country, statutes of limitation would go for about 6 years. In fact, given that they can probably only go to the OIA, you could argue the period should be a lot shorter than that because they've got 6 months. I think it's about 6 months to go to the OIA. So there's a question whether it needs to be 5 years anyway. Yeah, I suspect there's a lot of stuff, particularly in departmental files, hanging around. And what often becomes an issue is, of course, the reference. At the end, the student writes in, or big accountancy firm writes in saying, we'd like to employ Joe. Academic reaches for the file and says, heck, hang on a minute, this student got a caution for plagiarism in his first year. What do we do? Recognizing times are hard, big accountancy firm is looking for any kind of excuse to shorten the list. If we mention this plagiarism, it's going to be the kiss of death to his application. Who would mention it? Given it's sitting there, it was a caution. First year, minor plagiarism. Just seeing on the chat page, who would mention it? Yeah, only guilty case. Yeah, got a caution. Kirsty's saying no. Rose, no. Marianne, Marie, you must have a lawyer in your family. Fantastic answer. I wouldn't mention, but can see the risk. Only guilty case. Okay, no coming through. Manasadi. Mohammed saying no. Okay, consensus seems to be no. I recently had to advise on this rather similar case, actually. The student was found guilty. By the way, if they're found not guilty, you absolutely don't touch it, of course. Even if you think he's a wrong un and the suspicions were strong and you don't know why he wasn't found guilty, it's a no. First of all, you need to be clear that the reference is asking you about something relating to character or plagiarism. So you might be able to get around it that way. It's about purely an aspect you need to come to. Problem is, it's about academic performance. We do see plagiarism as linked to academic performance. So you can't just say it's about character. So there's a fair chance you have to wander into it. Certainly under UK law, the responsibility is when you write a reference, it must be fair and reasonable. And you owe the duty to both the student and the future employer. I suspect most people, though, would say, I'm not going to mention it. And I have to say, being pragmatic, I would probably say, yeah, don't. There can be occasions where if it's a serious case, so let's say in the third year, he almost got expelled. It's quite a serious case. He had to retake. Very few mitigating circumstances, and lucky to get away with the retake. And in fact, in the end, it affects his overall mark. Now, would people mention that? A serious case. Bearing in mind, it's probably going to kill his chances of getting the job. Reaction from people. Peter's still saying, I think no. Just no. We've got a probably there. Again, a no. So getting a few more people excited this one. Again, another no. Manas. Yes, clearly the thing we're talking about here, Monica, is the degree of severity, and also how contemporary it is. It's not like it was in his first year; it was quite recent, and you know, in the first year, you'd like to believe he's learned his lesson since then. I have to say that is a very difficult call as a lawyer. I would be thinking the argument there for mentioning it is much stronger. How can you deal with that? First off, you can say to the student, I'm sorry, if I give a reference, I have to mention this. And legally, so in this country, I don't have to write your reference. So unless you're happy for me to mention this, I can't write the reference. Another way of doing it, which is not brilliant, is that you deal with it through some cover language. So you say, for example, in the reference, glowing reference bit. However, there were some concerns relating to referencing, please speak to the student for further information. So in a sense, then you're encouraging the student to shop themselves. And I think you've kind of acquitted yourself reasonably by flagging it up. It will probably still mean that he won't get the job, but at least you perhaps ease your conscience. As I think, as Alan said, that just refuse to write the reference. Problem is, in these days, if you're the most obvious referee and you don't write the reference, he won't get the job. So there's a lot of pressure on you to get this bit right. Okay. We have had one or two occasions where references have kicked off. It is rare, and I understand why people will often say, take the low risk option, not mention it, because what are the chances of it ever being found out? Probably low. Final thing I've got there about consistency. Now, I see this as an emerging problem when people devolve more and more decisions to departments for informed resolution. Now, maybe we all accept that because decisions are informal, we don't need to keep a record of them. Interesting, can I just ask for some response on the chat area? How many people centrally keep records of decisions made in departments? So those informal cautions, lower penalties. Okay, so we've got a mixed bag coming up. So Monica's saying yes, Kirsty's saying yes, but you're a small institution, particularly obviously back. More difficult when you've got a big university like Leeds. Okay, Olympia not having decisions at departments. Certainly we devolve the more minor offences to departments. Department will keep a copy, but is that ever recorded in centre? Because if not, who's looking to see that decisions are sort of consistent? Yeah, I think it's a problem area. If you're looking to see that treatment of students is sort of fair across the institution, which I think is important actually, unless you've got a record of what's going on, you're never going to know. Now maybe we just live with that. And we say departments can do what they like, give them guidelines, and off they go. And if in history you'd be sent down the road, but in geography you wouldn't, we'll just live with it. Just instinctively doesn't sound kind of the values we all want to buy up to. Bit of an issue then. Okay, got to faculty are encouraged to report confidential chats, but not mandatory. Okay. I think here at Leeds, we don't. We get to know, but I'm not sure there's a central log anywhere for all decisions that are made. Jill, I'm conscious that this is down for an hour. What would you like to do now?
Have you got any further points you wanted to go through, Adrian?
No.
No? Okay. Do people have any quick questions for Adrian at this point? Because I'm worried that we are slightly over. Is there anything you'd like to pick up from the chat, Adrian? I think we've probably addressed pretty much everything. Are you surprised by responses there?
No, not really. I suppose I'm always interested to see the one about who's letting lawyers in, because, well, that's not just self-interest. There is a nightmare. It's if we start letting lawyers in representing students, you need to think through the consequences. Because what happens then is that the team bringing the case, they'll want legal representation, and then probably the panel will say, well, who's going to advise us? So all of a sudden, you've created a whole new legal department. And you can imagine how much each case would cost to bring, and that's going to put people off. So it may be against my interest, but if we can resist that for as long as possible, that would be great. But they are beginning to creep in here and there.
Obviously good news for you, Adrian.
And that, well, I'm not sure in these times of austerity. It is good news,
No,
actually.
no. Well, you've gone to the other side now, haven't you?
No, that's right. I'm no longer on the dark side. I've seen the light. I'm
That's
no
right.
longer paid by hour.
Okay, well, I think we'll probably round off there. Lots of thanks for Adrian on the chat window there, and I'd like to thank Adrian for sharing his views and maybe giving a slightly different view to the views that have come from the previous webinars, but lots of issues that I think that we need to think about, and a lot of things that we need to think about when we're writing policies, that we make sure that we're very clear about, and that it is all down there in black and white, if you like. Just to round off, I just wanted, as this is the last webinar, I just wanted to thank everyone who's participated in the webinars. If you've been here for the whole 6, that's great. We will be giving certificates of attendance if people want them, and I'll email you separately regarding that. But just also to let you know that all the sessions have been recorded and they're available on our website. That's www.plagiarismadvice.org/webinars. So I'd certainly be interested in your feedback, and please feel free to share the sessions with colleagues who haven't been able to attend. So thank you for attending. Thanks for Adrian for his perspective today, and hopefully I'll see you again. Thank you.
Thanks, bye.